Number 199, the people of the state of New York versus Robert Patterson.
Good afternoon. My name is Ellen Dilley. I represent defendant appellant Robert Patterson. With the court's permission, I'd like to reserve 3 minutes for rebuttal.
You may.
Thank you. The issue in this case is whether the trial court erred by admitting in evidence the subscriber information that was contained in 2 sets of prepaid cell phone records under the business rule exception.
Can I start, before we get into the business rule exception, just putting a little context on this?
Mm-hmm.
These charges were brought, as were a number of other charges involving other robbery cases, right?
Correct.
And you moved for, or the defendant moved for severance.
Mm-hmm.
And that was granted, right? And that was granted because in the other cases, there was no corroborating evidence of the eyewitness identification. Am I right so far?
Because in the case that went to trial, the Johnson case, there was corroborating evidence in the form.
The corroborating evidence were these phone records.
Correct.
Okay. So if we, and those matters have been resolved.
The other cases were resolved after this trial.
Okay.
That's right.
If we were to reverse, the people would have lost the opportunity to try them all together as a pattern crime, correct?
If you reverse.
And it goes, or I'm sorry, if it goes back for a new trial.
Well, the way the pleas were structured, one of the 3 other cases carries a consecutive sentence of 10 years. The other sentences, if my recollection serves, are lesser concurrent sentences.
What I'm suggesting is that the people's proof would have been different. Would they not have?
It would have been a completely different trial. I mean, in addition.
And so what you did was you argued for severance, you got severance on the basis of these records, and then you, and now you're, and then the defendant moved to
That is not.
include this evidence, right?
We addressed this in the reply brief. There's a very long footnote that goes through exactly the sequence of events. The court did say on the record it was going to grant the defense attorney's application for severance, but then he brought in the issue of the admissibility under the business records exception of the subscriber information. The court held its decision to sever in abeyance until after lengthy conversation about the admissibility issue, it decided that because it was letting this evidence in under the business records exception, it was going to adhere to its decision to sever. In addition, it said, I believe it said, it would have granted severance in any event because of the possibility that there might be other evidence in the Johnson case, namely testimony by one of the co-defendants. So there was no gamesmanship here. The trial attorney kept them separate, the judge kept them separate, and I hope, does that answer your question?
Going to the hearsay problem, and this case is somewhat baffling to me because intuitively you would think this would go to weight. But, and I know the cases, but the records come in, as I understand it, this is not your client's name.
The name on the Sprint records is Darnell Patterson.
Right.
My client's name is Robert Patterson.
So what's the truth of that statement?
The truth of the subscriber information, it's admitted as direct evidence for the contents.
We're in a really technical area of hearsay here, which again, to me is somewhat counterintuitive. But you're saying it's hearsay, it's being admitted for the truth. That's hearsay, right?
Right.
But the truth would be this 10-year-old or whoever the hell that Darnell Patterson is got this phone. That's what that statement says. That's the truth of that statement.
The truth of the statement, and the reason it's hearsay, is it's admitted to show that Darnell Patterson is connected to the Sprint phone. That was taken and used as circumstantial evidence
Right.
that Robert Patterson was Darnell. On the prosecutor's application, the court had
But it wasn't
Mr.
used
Patterson
for
show the tattoo of Darnell on his
But it wasn't used
hand.
for the truth of the fact that the son got the cell phone, which is what the subscriber record shows.
The truth is for the entry, the information that's in the records. It showed under the name Darnell Patterson, my client's
But they
date
didn't
of
admit it
birth,
for
and an
that.
address.
They didn't admit it to show that, I'm sorry if I'm confusing the names, but Darnell Patterson got the phone. They didn't admit it for that. They weren't arguing Darnell Patterson got the phone. So how is it coming in for the truth?
They absolutely used it. Robert Patterson is my client.
Right.
Direct evidence is Darnell Patterson. Circumstantial evidence is Robert Patterson. And
Right.
because the two phones, it's not just the Sprint records, it's also the T-Mobile records that are tied to the female accomplice.
But they weren't trying, you say direct evidence is that it was Darnell Patterson. That is not what
Right.
they're trying to prove. They're not trying
It's
to prove
used-
that actually the subscriber was Darnell Patterson. What they're trying to prove is that there's a connection here.
And they're trying to prove ultimately that the call went to this phone and he had the phone. That's what they're trying to prove.
Right.
And they're doing that by a number of different circumstantial factors, such as this phone calls 5 numbers that your client called from Rikers. That's all going towards the circumstantial proof that he has this phone at the relevant time. One of those things is that the name on this is the son's name. But it's not, that record doesn't come in for they're not arguing Darnell Patterson went and got this phone and gave it to his father. They're arguing a connection between that phone and the defendant to argue circumstantially that he has the phone at the time the crime is committed and he's called.
I'm not
Well,
sure,
if
Your
it's
Honor.
not that truth, what's the connection, what's the relevance of the phone?
I'm sorry,
If
Your
the
Honor.
truth is not the son and the father's connection, what's the point of the phone?
I'm
And what
confused about
records-
the son. I don't, is that,
Well, the phone relevance to me seems in this case that at this point in the robbery, it's called, right? The phone is called and somebody comes and there's a robbery, right, generally?
the people introduced it to show that Robert Patterson, my client, was Darnell Patterson, who was in communication with a female accomplice who supposedly
Right.
set up the
So
crime.
what I'm getting at is it's the communication, right, that's important to
It's
this
the
crime.
link. It's the link between the woman in
Right.
the complainant's apartment and the person who has the phone.
So they're trying to put the phone in your client's hand when that call is made from the woman who's in the apartment.
Yes.
And they do it in various ways. I mean, they could have just put these subscriber records in with no subscriber and argued, for example, not this case, but, hey, your client's mother is called on this phone, 5 minutes after this call and is also called from Rikers Island. They could have done that. And that's all circumstantial evidence that he has the phone. What they did in addition to that was they put in a statement that Darnell Patterson is the subscriber of this phone, which no one believes. No one accepts that as true. So since we're in, again, a very technical area of hearsay, because obviously this is probative proof, what is the truth of that statement that's coming in for?
The truth of the statement is the contents of the records themselves, that the subscribers, the people who have the phones, are Darnell Patterson and Deshelle Marrero, the female
Counsel,
accomplice.
is there any scenario that this information would have come in as non-hearsay information?
Well, that's the prosecution's entire argument.
Do you agree with that, that it could have come in as non-hearsay?
No, I don't, because first of all, the prosecution has never identified a relevant non-hearsay purpose for this evidence. The evidence of the identity of the subscribers of the two phones is only relevant for its truth. If somebody else activates the phones, has no relevance, does not implicate Mr. Patterson in any of the crimes.
Why doesn't it complete the narrative? Why doesn't it get you to why the investigation leads to the door of your
Well,
client?
For one thing, the trial judge rejected that claim. And if it had, there would have been a limiting instruction in this case. No limiting instruction was ever given after the
If the
records came
judge
into
made an
evidence.
error about whether or not this could have been used to complete the narrative, is your fallback that, but you don't have obviously, then you don't have the limiting instruction, and you've got to have the limiting instruction if you're bringing in this kind of evidence for completion of the narrative?
Completing the narrative might have been an acceptable use, but that's not what happened here. The judge
What about
explicitly
the
rejected
reason that
that.
the appellate division gave, that it's like pedigree information?
Well, the gist of the appellate division's decision was that because the subscriber information was used as circumstantial evidence, that is somehow non-factual, and therefore it's not hearsay. And we disagree with that because all evidence is factual, right? Circumstantial evidence is direct evidence of a fact from which you may infer the existence or non-existence of another fact. It's still factual. And because it's factual and it's considered for its truth, in this case, without any limitation from the court, it's hearsay.
Well,
That-
they analogize it to a fingerprint.
Yes, they do, Your Honor, but I am hard-pressed to see how a fingerprint is a statement, so I don't think that has any hearsay implications whatsoever. I'm at a loss on that one.
Thank you, Ms. Dilly.
Thank you.
Counsel?
May it please the court, Ryan Mansell for the Bronx County District Attorney's Office. Going right to Justice Garcia's question points exactly to what we are asking this court to do in this case, which is to apply the hearsay rule in the same way that the lower departments apply it, that it was applied in this case, and that other jurisdictions with the same hearsay rule choose to apply that rule. And that is for the truth of the facts asserted in the statement. And I think the key distinction in this case is that we didn't bring it in for its truth. And there's a distinction between accuracy and veracity.
What did you bring it in for?
We brought it in simply to show the fact of the occurrence, the fact that someone called up Sprint and left a specific set of information with the Sprint
It's a
representative.
non-hearsay purpose.
Correct. That's a non-hearsay purpose because we don't care what the date of birth is of the defendant. We don't care where he actually lives. We don't actually care what his real name may or may not be. We're simply trying to show that the information that was left with the Sprint representative matches the information that defendant provided at various times. He provided the same date of birth when he was arrested. He had the address had come up during an NYPD database search by the detective. The name was tattooed on his hand. We didn't actually care that the birth date was June 4th, 1986. We only cared that the information that was provided to Sprint matched the information that was provided by the defendant. Whether it was his real birthday or not didn't matter for the reason we were introducing it into evidence. And that's the distinction between accuracy and veracity. It mattered that the last name was Patterson, that the first name was Darnell, just as it would have mattered or made a difference.
So then you're not looking for a hearsay exception? You're looking for it to fit under some other category? What's that other category that you presented to the trial court?
Well, the other category that we presented to the trial court, and we very clearly said this when we were making our argument, was that we were bringing in for the non-hearsay purpose simply to show that the information had been provided. And the court agreed. They said in their oral ruling specifically that they were letting it in only for the purpose of showing that somebody had left that information. They said the same thing in the written ruling, that it was coming in only for the occurrence of the fact that the information was left. That's what the appellate division
Didn't care
affirmed
whether
on.
that person was Darnell Patterson or Robert Patterson or Jane Smith, or it didn't matter who that person was that provided the information.
Exactly, Judge Rivera. It didn't matter who actually provided I'm sorry, Judge Stein. It didn't
Although
matter.
I'm pleased that you
My
would think
apologies.
I'm Judge Stein. Thank you.
It didn't matter who actually provided the information. We simply wanted to show the same way you would show with a prior and consistent statement. For instance, if a defendant had previously lied about their alibi, saying they were at the mall and then they later said that they were at a neighbor's house, the accuracy of the statements matter. The fact that he said mall before and that he said neighbor's house this time, the accuracy matters. We don't actually care where he was. The same way in this case, we don't actually care what the truth of the statement is. We just care that the sets of information provided match. And that's the same situation that happened in the Lieberman case, the same situation in the Cindy Van Tran case.
So why isn't that the truth that he's the one who provided it? Why isn't that the truth you're trying to match up to?
Because the
As opposed to the content. I get your point there.
Because the formulation of the hearsay rule that this court articulated in Huertas is the truth of the facts asserted in it, in the statement. We're confined to looking at the four corners of the statement. The way I would say to look at this is as collateral facts. There are things, even when
So it's too bad for the defendant that he lied.
Well, even if the statements were true, we would still say that they come in, because again, we're just looking for the fact that they match. So for
But
instance,
is that how the trial court said they were coming in? It wasn't clear to me from the colloquy and the court's ruling in the transcript that the court was saying it's coming in on a non-hearsay basis.
I would say two things, Justice Abdus Salam, to that, which is First, I would say that the court was very clear that it recognized defendant's exact argument, that there was a business duty on the supplier. And it would be tough to argue that somehow the court recognized that very requirement, but yet still let it in while disregarding that requirement. And in fact, if you read defendant's briefs in this case, nowhere do they point to anywhere where the court said that it was coming in for its truth.
Yeah, but just to follow up, it seems like there's a distinction between what was said orally by the court and then the written decision that was a while later. I'm not sure. There's a big time gap. The written decision seems clear. I give you that. But the oral decision of the court, it doesn't really give us the same kind of clarity.
Well, I don't agree, Judge Fahey, for the reason that the court said in the oral ruling that it was coming in for the purpose of showing that this is the information that was given, for which somebody gave the information, Darnell Patterson. That's the same language as saying in the written ruling it's coming in for the fact of the occurrence itself.
The court also said, counsel, in that same colloquy that it would be permissible through the CPLR, but she wasn't going to let it in through the CPLR. You had to bring in a witness to testify to it. So I still think it's a little unclear what the court was saying about how the information was coming in, whether it was a hearsay or a non-hearsay purpose.
Well, Your Honor, I would say two things to that. The first thing I would say is that conversation dealt more as to whether it would qualify as a certified record. And the issue there was because there was a disclaimer about veracity in the document. So that wasn't actually about the business record exception itself. It was about a collateral matter as to what foundation would have to be laid for it to come in. But the second thing is that there was no dispute in this case that the Sprint records were going to come in. And the way that defense counsel before trial characterized it was hearsay within hearsay. And when asked, he specifically said that he wasn't objecting to the call log. So, of course, in the oral ruling, there's still going to be some discussion about the fact that this is hearsay contained within a business record and whether or not that hearsay is actually going to be considered hearsay or is going to come in for a non-hearsay purpose. And to go directly to that point is the Third Department's decision in State v. Hayes, which this court affirmed. And in that case, the Third Department was trying to reconcile this court's decision in Johnson v. Letts with this court's decision in Kelly v. Wasserman. And the way the court did that was to say that it was very clear that the record itself and everything contained within the record, except for the hearsay within hearsay, could come in as a business record, but that without another justification or another exception, the hearsay within the record couldn't come in unless it was being used for a non-hearsay purpose. So that's what the trial court was articulating, that there's this shell of a business record that comes in, and then there's this hearsay within hearsay issue, and as for that issue, it's non-hearsay. And this court affirmed that decision by the Third Department, and that's the decision that should control in this case, because the exact same thing was articulated by the trial court here. So when we're discussing whether or not the information came in for its truth or falsity, or whether it would have made a difference in this case whether or not the information is true, we say the fact that the information was false is also the reason why the inference regarding the limiting instruction doesn't hold here. Because counsel's best argument at summation would have been to say that you should consider this statement for its truth, that some other person named Darnell Patterson, who actually does live at 1854 Cedar Avenue, because as we heard during the hearing in this case, this defendant actually lives at 184th Street, that the person who actually lives at that address, who actually has that name, is the person who subscribed to the phone and who was the person who committed these crimes. So a limiting instruction would have actually precluded defense counsel from making the very best argument that he could have made at closing, which was that somebody else was the owner of the phone. So he wouldn't have wanted a limiting instruction. And when he said in the record that of course he would want one, that was simply a knee-jerk reaction to the court asking him, well, if I let it in as non-hearsay, would you want a limiting instruction? There was no actual dialogue or discussion about that. And the fact that counsel didn't later ask for a limiting instruction, I don't think should control in this case. And that points to a very important point in this case, which is that we don't get to any of these business record exception arguments in this case unless we look specifically to the inferences that defense counsel asked us to draw from the later conduct of the parties, because counsel cannot point to anything in any ruling by any court which says it was coming in for the truth or that it was specifically the subscriber information that was coming in under the business record exception. So for instance, look to the litigation that took place over the second set of business records here. What we argued was that there was a big difference between the Daichel Gore records, which came in under the T-Mobile representative, and defendants' records, which came in under the Sprint Nextel representative. If we had won the business record exception litigation in the very beginning pre-trial, we wouldn't have been arguing about the differences between the records. We would have been trying to point to their similarities, to say that the court should rule the same way with the Deichel records as it had ruled with the Sprint Nextel records. And I may see my time has expired, but just to put a capstone on this, it's simply to say that in a scenario like that one, we would have been trying to get them in under the business record exception because in that particular situation or in that particular scenario, that would have been the best possible income for the strength of the evidence. So we were making that argument because we wanted a different ruling than what we had gotten in the first place. And so for those reasons, this court should affirm the ruling of the appellate division and uphold the ruling of the trial court. Thank you.
Thank you, Counselor. Ms. Dilley?
Well, I'm not really sure where to start. The reference to the third department case in Hayes affirmed by this court, I don't recall that that was included in my briefs, and I don't know the case, and I'd ask the court not to consider it because I don't think it's properly before you. Getting back to the beginning, the information, the prosecution's theory that the information was provided as set forth in the records, is only relevant if it tends to inculpate Mr. Patterson. And the subscriber information
Well, all
only-
evidence is admitted because it tends to inculpate, but that doesn't mean that it's hearsay or
No.
that it's offered for its truth.
Correct. But initially, this theory, the non-hearsay theory, has no relevance unless it's offered for its truth.
But the hearsay rule says for the truth of the matter asserted in the statement. And the matter asserted in the statement is that a Darnell Patterson living at a certain address of a certain, subscribed to this phone,
Correct.
okay?
Correct.
So
That-
if they're trying to prove that, unless they're trying to prove that he's Darnell Patterson, which it
That's
doesn't-
absolutely that was the whole point of the tattoo. That was the whole point of the tattoo. The court said the tattoo comes in as circumstantial evidence, but the only thing that makes that relevant is if the subscriber information comes in. And that's the first link. That's the
But
first
your
step in the
argument is not that they're
circumstantial
trying to
chain.
prove he's Darnell. Your argument is they're
trying to
trying to
prove
prove
that
he's
Darnell
the
is my client.
Excuse me. Not that he's Darnell, that he's the person who registered this phone,
Correct.
right?
Correct.
Which, so again,
But that's
the
not in
defendant
statement.
could have lied, and it's not the accurate information, and they're just trying to get in the information and then link him to your client.
Well,
Which is not the same as saying, I'm putting this information to show that whoever this Darnell person is, Darnell is the person who registered the phone.
Theoretically, that would be possible, but that's absolutely not what happened in this case. The prosecutor used this throughout the trial, throughout the pretrial colloquy, as proof that my client was a subscriber, and therefore link him to the crime. It was...
You mean as an alias, that this was his alias?
Yeah, that was an argument. That was the argument when counsel moved for an expert ID witness on this case. She said, oh, no, we have corroborating evidence. This is independent the cell phone records, the subscriber information is independent corroborating evidence.
But the statement doesn't say that Darnell Patterson, whose real name is Robert Patterson, living at this address, subscribed to this phone. That's not what it says. That's not in the statement.
It says, it lists the subscriber as Darnell Patterson at a given address with a given date of birth, which then the prosecution, using other evidence, direct circumstantial evidence, direct evidence of a fact. This was introduced as circumstantial evidence for its truth. It's direct evidence of a fact. It's not non-hearsay. It's admitted for its truth, because
Yeah, I thought the truth they were trying to prove was that he used the phone, not that he was Darnell Patterson. I didn't think that anybody cared one way or the other. That's the way I understood it.
it's
kind of-
both.
kind of the-
They
the-
need both.
I was thinking of the Lieberman case, that kind of analysis. So that's the way I saw it.
Well, again, they need both. It's the Darnell Patterson in the records is the first step in the circumstantial evidence by which they prove that Darnell Patterson is Robert Patterson. Darnell is a name tattooed on my client's hand, and that therefore Robert Patterson is one of the robbers who's in a communication with the female accomplice who's in the complainant's apartment.
Thank you, counsel.
Thank you.